So there's a lot of ground I want to cover here. Of course, I want to talk about your experience with the trial, but also a new motion that you filed. But let's start with just take me back into the courtroom. The day that Judge Charles Sims read the verdict, what was going through your head?
You know, the verdict came back really quickly. Both Kevin and I have been on this case for a little over 2 years, somewhere around there. And we still have not solved the case in any way. So it was very troubling for me when I found that the jury had come back in 5 hours and already rendered a verdict. So I was, while I was optimistic leading into the verdict coming back, I was very shocked when the verdict was actually read. It was not what we were expecting from our team at all.
Why?
I believe that the evidence against Joey was very flimsy. There was not a ton of substance there. There were a few one-off comments that he had made to people over the years, most with horrible credibility issues, almost all with drug issues themselves. The fact that the cell phone evidence was in my mind clear that Joey Lawson or Steve Lawson's phone was traveling down Boston Road with the contemporaneous story of the other car, the Chrysler 300 that they were searching for. I really believe that we had proved by preponderance of the evidence that in fact Joey could not have committed the crime. And ultimately the jury disagreed with us, and we respect that.
But to be clear too, in a criminal defense or in a criminal case, the defendant doesn't have any burden at all, right? So what I think Mr. Boyd's talking about there is, that we proved anything at all should have been enough for what is reasonable doubt. And I think when we handed that case off to the jury, and I think all of our heads, there was absolutely doubt, and those doubts were reasonable. Because of that, that verdict is still shocking.
You both were sitting next to Joey when the verdict came down. What was his reaction, and what were some of the first words exchanged?
Well, I was actually sitting right next to Joey when the verdict was read. Of course, we allowed the jury to exit before we had any communications with one another, and I just looked down at Joey and told him I was sorry. And he was very reserved, and he looked at me and he said, "Brother, you can't control what those 12 people just did there." So he was very reserved, very appropriate, and honestly, he took it better than I had expected, because again, I don't believe any of us were expecting them to come back with that verdict.
What was it like to work with him as a client?
I'll be honest with you, he was probably one of the best clients that I've ever had to work with. He was respectful, he was polite, he was courteous, and he was also helpful. He was an integral part of his defense team. And with a case that's this complex, when you have so many 10 years of evidence that you have to go through and countless people that you have to sort and figure out what their role is in the case, Joey played a great role in connecting those dots for us, because he had lived this and he was familiar with the case much more than we were out of the gate.
Mr. Coleman, I believe it was in your opening statements, you used the phrase collateral damage.
Mm-hmm.
Can you explain that?
Yeah, so I think what we saw throughout trial is KSB in particular, but the government overall, because the Commonwealth Attorney's Office was involved with the investigation very heavily. But you saw what they were willing to do in order to get their ultimate prize, which was a conviction for Brooks Houck. And Joey was an example of that, as far as that's the phrase, right? Is that he was collateral damage to what was ultimately their main purpose, which was to convict Brooks Houck.
And that being one of the leading factors into this motion that was filed for a retrial or to drop the verdict. Explain to me that motion and what some of the points in that motion are that you're arguing.
You know, this was I guess we're piggybacking off a motion that was filed probably at the outset of the case when we were arguing severance. There was just a gross disparity of evidence between Mr. Houck and Mr. Lawson that was brought out during this trial. I believe I'd said in my closing that it was 3 days into trial before we'd even heard Joey Lawson's name mentioned. So that was something that was very difficult to overcome, sitting there day after day for 2.5 weeks with all this evidence coming in against Mr. Houck. And relatively little coming in against Mr. Lawson, Joey Lawson. So I do believe that had a spillover effect and definitely prejudiced Joey in getting a fair and impartial trial. We also believe there are some issues with the jury instructions. It was unclear whether or not in the tampering and the conspiracy charge, there was an issue with moving the car and or the body. So not to go too into the weeds with the legalistics of that, but it's a unanimity issue as far as whether or not that conviction will be upheld on appeal.
Basically, so they put an and or in there. So as a factual determination, we still don't know whether or not that jury said that they believed that Joey moved the car, and that's the basis of the convictions, because that was the basis of convictions for both counts, or whether or not they believe that he moved a body. And so every person who's ever put on trial for a criminal trial, they're entitled to a unanimous verdict, and that is a factual issue that's going to be at issue, right? So theoretically 6 people could have said car, other 6 people could have said body, right? And had those actually been properly separated as different charges, then you potentially could have been acquitted because or at least a hung jury on those counts. Does that make sense?
Mm-hmm. Additionally, we had the elephant in the room of Steve Lawson. I believe that his name was said so many times throughout the trial, it was perhaps confusing for the jury at times to distinguish which Lawson was being spoken of. So, I don't think anybody understood the media spectacle that was going to unfold from the Steve Lawson trial. I certainly didn't expect it, and I think that had an impact on the jury pool and tainted the jury pool that was actually seated in the trial for Joey Lawson and Brooks Houck.
In that vein, how do you suppose Joey could have ever gone a fair trial if Steve stuck with all of the jury pool?
Honestly, I believe we should have moved to a separate media market outside of that. And that was something that we didn't raise pre-trial. I believe that we all operated in good faith thinking that this was a fair strategy. So I don't blame the court or any other actors involved in that. But I do think that this being a unique case, this was a situation that was unforeseen to really anybody that was involved in the planning of it.
So in the case of a retrial, you would want to go elsewhere in Kentucky?
Certainly.
I think you do raise a good question, which is more, at a kind of a zoomed out level, is when you have a case that has that much pre-trial publicity, especially in this day and age with internet and cell phones and things like that, is there anywhere in the state of Kentucky that you can really go to avoid that kind of pretrial publicity, and it's difficult to answer whether or not you could go somewhere else and get a fairer trial.
You two spoke minimally during the trial. Was there a lack of an argument from the defense for Joseph Lawson?
To be honest with you, again, going back to the disparity of evidence between the two parties, most of the witnesses that went up there had nothing to say against Joey. They didn't know Joey. They had no evidence regarding him, so there was simply no point in asking any questions. I will give credit to Mr. Houck's legal team. He has some great lawyers, and because of the order that we went in, his team would cross-examine first, and then we would cross-examine second after them. Just for the sake of time, if all of the issues had been covered in their cross, we opted to not just get up and repeat ourselves and waste the jury's time and just keep the trial moving forward.
Mr. Boyd, you said a quote. You said Steve's name was mentioned significantly more than Joey's. What testimony or what evidence do you think stuck with the jurors to find Joey guilty?
Honestly, I believe it was the testimony of Charlie Girdley, who I found to be one of the most uncredible witnesses I've ever seen brought before the court. He had had 6 to 8 different stories before he landed on the one that he finally came in and told the court. He's been all over the place. He'd been up high on meth for 5 or 6 days when he made that statement. You know, and when the jury requested to view something from the evidence, it was his direct testimony. So while I'm shocked and surprised that they did, I believe that they believed his testimony to be true, and Charlie was the one link that could link Joey to Brooks, and the state Commonwealth needed somebody to provide a physical link between Brooks and her car and what happened that evening.
Why would a jury believe Charlie Girdley and not with the both of you?
I have no idea. I don't understand. I have rarely seen a witness so thoroughly impeached and have a jury give their testimony any credibility.
Yeah, and on top of that, there's the corroboration of actual physical evidence. They convicted based off of witness testimony and the fallibility of human memory. And Charlie Girdley's was the memory that they were relying on. I think that question can only be answered by that jury, and it showed that they did believe him, and they saw his testimony as valuable because the one thing they requested to review was his testimony. That was the only thing that they wanted to re-review, and that's when we came back in and we sat there and watched Charlie Girdley's testimony. And yeah, I mean, it was incredible. Whenever you're joined, you end up, whenever you're joined with another defendant, there is risk of loss of control over the narrative and over the defense, right? And obviously they had a lot more to address than us, so there was a certain amount of that went on.
So if you could control the narrative more, what would you have said in the courtroom?
That the case, so in order to prove beyond reasonable doubt, we don't just rely on what people said. We go to other things to verify what they said. And when they did that here, they did not find those things. And in fact, they were exonerating for Joey. And those are reasonable doubts, right? That's the reason why it's the highest standard that there is. And to some extent, I feel like we still got that narrative across. Because mind you, what Brian Butler and Steve Shoring did in there was in line with what we were saying about Joey as well. So whether it was us speaking or the same kind of messages that were being sent by them, they would have been consistent to some extent. I think I was kind of more talking in the vein of when we did get up there, it was not after having kind of gone through all the motions and stuff like that to get into a flow.
I'm not sure how we could have combated this better, but I was frustrated that the jury seemingly dismissed the cell phone data. Mm-hmm. I think that if Ms. Rogers' car had been found at 7645 Boston Road, Mr. Lawson should be going to prison, but it was found at mile marker 14 on the Bluegrass, and all the cell phone data evidence supports that he was traveling down Boston Road at that time, not the Bluegrass Parkway, and wasn't traveling down the Bluegrass Parkway at any time during that leading up to or after that time period.
Well, hours were spent going through that cell phone data. Very precise graphs that the jury was shown for hours. technological lingo that was tough to understand at times. Why do you think the Boston Road argument didn't stick with the jury?
Again, I'm not sure. It was very clear that Mr. Steve Lawson was trying to contact Capital One to see if it had been repossessed. He then starts looking up the Heather Snellen's boyfriend to determine where he lived, and that's when he found the Boston Road address. It was contemporaneous with the timeline of Miss Snellen stealing his car that night. It was within about an hour of that happening or occurring that he realized that. And the cell phone data clearly showing from even the government's report that they were pinging to the north of the towers consistent with travel down Boston Road. I really am not certain what else could have been done to present that to that jury in a more effective way.
I want to bring up a transcript from some documents that were unsealed just a few days ago from the Nelson County Circuit Court. This is a transcription of a 2023 grand jury recording. Speaking is a female juror and Steve Lawson. The female juror says, "So did you think your son had something to do? I mean, since you moved the seat and stuff, did you think that your son was involved?" Steve Lawson says, "Well, I mean, he plain and simple, we was involved in moving the car." The female juror says, "Okay, that's ... Steve Lawson says, "That's automatically, that's a crime, you know? It's that simple. We've both done implicated ourselves into a crime, so now we're both pretty much hemmed up." The male juror says, "But you didn't know it was a crime because you didn't know Crystal was gone." Steve says, "Exactly." Your thoughts on this? Of course, this was not admissible into either trial, neither Steve Lawson or the Houck Joey Lawson trial.
So first I'll talk about, this is a great example of just the fallibility of human beings and testimony, by itself, and then we'll talk about Steve Lawson specifically. But first, Steve Lawson, like a lot of other witnesses that testified in this case, you have to look at the full context, not just this one statement, right? So Steve Lawson also had the context of being promised immunity, right? And that all came out in pretrial litigation. So in other words, he was being given an offer of dismissal in exchange for what they wanted to be, what they claimed to be the truth, right? Now, the truth, I think, in this situation was going to be in the eye of the beholder, and it didn't match up with their version of the truth, meaning the government, and then that's why that deal fell through. But what Steve Lawson was doing here is that he was changing his story once again, because his first story, and there's a series of stories that he has, but his first story that was the most contemporaneous with 2015, he denies any involvement in anything, okay? And then after being interviewed a number of times coercively and given promises of leniency and things like that, that's when we get these tales. Steve, I think, is still convinced that he should have gotten that immunity, and I think that's why he is stuck to that story, this one.
Steve's statements are the product of some of the most extensive interviewing of anybody in this case, and countless people were held and interviewed for multiple hours at a time. I would be surprised. I would say Steve Lawson was probably interviewed upwards of 20 to 30 hours over multiple different days and times. Oftentimes he had a warrant that he knew was out for his arrest while he was making these statements. And if he said if he said something that was consistent with what the detectives were searching for, they would allow him to stay out that night and come back and continue the interrogation another day. So it really is the story that Charlie Girdley gave that he ended up with. Steve Lawson was a very similar product of that interrogation process, where multiple stories were created over multiple interrogations, and when you get to something like this, that's the end. That's what's stuck at the end for the investigation. not necessarily the truth, in my opinion.
Yeah, the difference between Steve Lawson and Charlie Girdley is that Steve Lawson was charged. Charlie Girdley was a suspect as well, and I'm sure that if he hadn't said what they wanted him to say, then he would have been charged as well. Charlie Girdley would have.
So you're sticking to your guns that that is not the truth because of police coercion?
I don't believe, and I hate to sound naive, but the cell phone evidence is indisputable. And this simply could not have happened. I've never been a believer in false confessions or anything of that sort. It makes me sound like it makes me feel like I'm talking crazy, but I do not believe this to be true.
It's pretty damning.
It is.
Yeah, if had he taken the stand, it wouldn't just have been that statement. You would have had a series of inconsistencies. The court even made a finding at some point that he was wildly inconsistent. And Steve Lawson, I think, is not above, making sure that he makes statements that are going to save his own butt.
Sentencing is coming up just next month. Do you think the judge will take the recommendation?
I mean, I think in my experience, more often than not, a judge is going to go along with the recommendation. I mean, whether or not he can't go up, he can't go any higher. But we'll certainly ask him to reduce it. But that ultimately will be up to him. Frankly, no, scratch that. I'm like, do I want to say that publicly?
At this point, we're presuming that the judge will issue and sentence Mr. Lawson to 25 years in prison. At that point, the Department of Public Advocacy Appellate Division will take over, and they will proceed with his appellate issues.
One of the things that bothered me, at least through the whole thing from beginning to end, was that everything was so tight-lipped, and it was for good reason. It was trying to preserve the ability to have a fair trial, but that lack of transparency, the lack of free flow of information, I think leads to a lot of people speculating and jumping to conclusions when they haven't, actually seen all the evidence or seen the big picture, and there's been a lot of that, and it's not even just since Joey was indicted. That's been happening for 10 years, where people have, I think it's our natural inclination as human beings just to try to connect dots with things, and I couldn't tell you how many people have approached me to say that they have solved everything, internet sleuths and stuff like that.
Up till now, we've had no ability to control the narrative in any regard. So post-trial, since we've already moved through that, at this time we appreciate the media, people like yourself, just sitting down so that we can tell Joey's side of the story to a broader audience that was outside of the courthouse.
Well, and also I think what transpired as far as those interviews, I think is a policy issue that is concerning. How law enforcement goes about investigating cases and securing convictions. We all have rights that are there and designed to make sure that the ends don't justify the means, and it was quite the opposite for them. The ends did justify the means, and they did a lot of terrible things to witnesses, to my client, to Steve Lawson, in order to get to the spot where they could get a guilty verdict for Brooks out.
There's one moment from the courtroom that stood out to me. Mr. Boyd, you, during closing arguments, you said, "That sophisticated businessman would not hire those two fools to do it." Walk me through why going at the Lawson's character was a part of your argument.
It was true. It was realistic. Mr. Lawson, Joey Lawson, was severely addicted to methamphetamines at that time. He was using alcohol in excess, He was, personally, he was in a very bad spot in his life. He was not responsible enough to even complete construction tasks for Mr. Houck, much less taking part in such an integral part of this alleged crime. I just don't believe that Mr. Houck would trust him to do anything of this sort.
And I would add to that, as far as you've got, if we're to believe that they did what this jury thought that they did, then that means that they would have been, criminal masterminds that were capable of cleaning multiple crime scenes and leave no trace of any sort of physical, forensic, DNA, trace evidence at multiple places. That you're basically saying that these two guys evaded the investigation of the full might of the federal government, FBI, IRS, KSP for the state government. All these resources, they somehow evaded any sort of detection. That would require them to have a level of knowledge about things that people, even if you're an attorney or if you're a police officer, that you don't know, you may well know, but to actually be able to accomplish that feat would be incredible in and of itself.
If you go back to that night, it was a rainy, hot, humid summer night. If you believe the government's narrative in this, Joey Lawson had to operate that car at least twice, if not more. And in the process of doing so, while he's high on drugs, likely drunk as well, in this humid, rainy environment, that he doesn't leave any DNA on anything anywhere in the car on these multiple times that he operated it. And the most troubling part of this, of the vehicle to myself, is the phone that actually has the fingerprint on it that doesn't match anybody involved in this case. And that seems to be the most important fingerprint that has not been, we don't know whose it is. And that is likely the last person that operated Crystal Ryder's car and placed her phone in the seat.
Behind closed doors, has Joseph Lawson looked at you and said, "I am not a part of the killing"?
Certainly. He has been adamant since day one that he was never in Crystal Ryder's car and he had nothing to do with it. And in fact, when Mr. Young wanted a couple of the hairs tested that had not been tested, there was an issue a few months ago about that. We actually agreed to have those hairs tested. And I told Joey, I said, if you were anywhere near that car, we don't have to allow them to test this. And he very quickly responded and said, I was never near that car. I never touched that car. Test them.
Sorry. And a copy of that order, it's in the court file. I don't know if it was sealed initially or not, but yeah, there's an agreed order for us to have those things tested, but they never were. So.
From an attorney's point of view, you never want to give the Commonwealth more evidence to convict your client. So for him to be so full-throated in his desire to proceed with the testing, I think that spoke volumes to me.
Mm-hmm.
That was telling to you.
Mm-hmm. Yep. And that goes with the typical attorney warnings of, you don't want to do this unless, you've got to be 110% sure this is not going to come back in the wrong way. And he, without hesitation, agreed to it. I think they even went and did what's called buccal swabs. So they have his DNA sample. They just never did it.
He even agreed to provide his DNA sample as a part of that.
Mm-hmm. Which normally you would have to have a search warrant for, or a court order of some sort. But we agreed to that part of their investigation. So.
Have you spoke to him since he's been in jail?
Yes. Mm-hmm.
Can you give us a look into those conversations?
Really, at this point, he's taken the verdict as best as he can. Certainly, he's not pleased with it, but he's reacted appropriately, and we've had conversations consistent with the attorney-client relationship we've had the entire time, and we've just discussed what moving forward the appellate options and what what our next moves are.
Have you found that he holds resentment towards anything?
Again, Joey has been one of the most wonderful clients to work with, and I know that's hard for a lot of people to hear. They might not understand that, but no, he has not shown any level of resentment. I mean, he's not happy about the process, obviously. He's not happy about it, but he has not acted out in any way that I'm aware of.
I think for Joey Lawson, his lot in life, the cards that he was dealt in life, actually have made him. I think it's made it difficult for him to actually have much faith in institutions, right? So I don't think that. I think some of his reaction was a lack of surprise, only because that it was consistent with what has happened, with these institutions in the past. So, this is somebody who has, obviously he's had an accident. He's in a wheelchair, but it's not just that. It goes much further. He was, born into, a wonderful father that was Steve Lawson, and this. You kind of saw, I think, parts of Bardstown and Nelson County that not everybody usually sees, right? And these are people that have had adversity, and they've been beaten down a lot. So it's not very shocking when something doesn't go their way.
I've asked our legal analyst Nick Mudd if there's any potential for a plea deal if Joseph Lawson were to if Joseph Lawson were to come forward with any information he has, if he would be able to get a couple years knocked off his sentence when the judge does make a determination on that. Is there any world in which a scenario like that could play out?
No. To be honest with you, I think if Joey Lawson could have done that, he would have done that. He simply can't.
There's no information to be given, and so kind of you saw how it played out with Steve Lawson. There is a truth that they are seeking, and there's knowledge that they are seeking, the Commonwealth and the government, and Steve Lawson was given every incentive in the world, to do it. In fact, he was given a blank check. He was given the offer his case to be dismissed, right? And he tried cooperating with them, and told them what he thought that they wanted to hear, and he still was charged, and he was still convicted, and he's looking at now a jury recommendation of 17 years, right? So there's no information to be given as far as what could help. He just doesn't have it. They're looking for something that's not there.
It's hard to make up the truth when you don't know the truth.